and its understanding. Right? There is a critical understanding of criminal law demanded, and that has been taking place for a greater part of time now. Right? So, but positivism played a significant role, and the focus of this particular school remained on treaties. So what they say that rather than going into the jurisprudential aspect of finding out what actually is the reason behind making of a particular law or unmaking of a particular law, look into the practical part, the empirical part of state. How do they engage with each other? How do they behave in a particular situation? How do they respond together? And that became the source behind making of analytical law school or positivist law school, right? The greater emphasis is what state does as a practice, and ultimately that practice which attains the status of a usage and thereafterwards followed by majority of states becomes custom, right? There's a difference between uh, practice, usage, and then ultimately reaching to a custom. This is something which you have already studied in your constitutional law classes. Similar principles you can adopt in terms of international law as well. So there are certain practices that state follows, right? They merely for following of those particular practices, they are not bound upon states or other states. They do not attain the status of a custom, right? Then it becomes a usage. There's a distinction between these three. If you do not know that particular distinction, just find it out. It's a very relevant part because in recent times as well, in constitutional law, the kind of development that we have been witnessing, we are also engaging our argument pertaining to practice, usage, and customs, right? So that's a very important aspect. International law says that the moment a particular practice has become or a usage has become a custom which is followed amongst the state as a matter of regular habitual behavior, that should be the force behind making of international law, the source behind making of international law. And you will find out that the 18th century and the 19th century was greatly influenced by those particular customary practices, right? And that's why whenever we are going to study about sources of international law, custom will play a very important role in any reading, right? Treaties also was a new phenomena, right? 18th and 19th century also saw certain formation of treaties, right? There is no logical reason behind as to why a particular state is entering into a particular treaty other than the requirement, right? The jurisprudential logic was not being seen, but this has been seen as an act of a state which greatly influenced the behavior of other states towards that particular state or leads to formation of new practices or new treaties, right? Because when state majority of a state coming together signing that Treaty of Westphalia, it compelled other states also to follow similar paths. Because one of the significant aspect of Westphalian Treaty is that it ensured sovereignty of a state, at the same point of a time demarcated the territory boundaries of states. So you can keep your army within those particular territory limits. Beyond that will be violation of the provisions of that particular treaty. And it greatly influenced the jurisprudence altogether pertaining to the development of international law. So this is one of the approach to international law. The idea remained that it should greatly focus around the empirical method. An empirical method is that you need to view a particular problem from the kind of solution states have found out, right? So that should be the force rather than the theory, the reasoning theory of which is what is the basis of natural law. They say that if there is a law which has been emerged, which has been formed in a particular society, it has to have certain elements, particularly the elements of morality to it, the elements of reason to it, right? And if that particular law does not believe centers around these particular requirement, it will not be treated as a proper law. It is not the ought law, right? So it is merely a law. Positivist says that law is what it is. It is not the ought proposition. Law cannot be told as to how it has to be, it has to govern the society or it has to run its existence. It doesn't. It is a law. It is being there by declared by a particular state. It will serve as a law for the subjects, right? There is no doubt with respect to its ought to be proposition. But naturalist believes differently. They say that there is a requirement of making of law. Of course, there is. But then that particular law to have greater acceptance within the society must serve the requirements, additional requirements, particularly in morality and reasoning. Right, and reason remain the most important source of international law. And the logic behind this is that when a law has reasons attached to it, it will serve the greater cause of the society, which is just, fair, and reasonable. Right, because the moment it has elements of morality, the moment it has like elements of reasons attached to it, it will lead to a society. It will treat the law will be treated as a just, fair, and reasonable. If it appears to be unfair, unjust, and unreasonable, it has all the possibility of getting like over. People will move beyond that particular law, and there will be a new law that come into picture. So that's the focus of like naturalist. Positivist, by the times Renaissance came, and they said that there is no such requirement, because naturalist, like natural law has various elements attached to it. One is reason. Second came the religion, and religion for a greater part of the human history did not serve the cause for development of law as such. Right? There were many restrictions. You cannot question the law. Renaissance was a remarkable change that took place, and it says that no, we do not find that particular logic reasonable. Whatever has been existing as a law in the society, and whatever is the practice of a state through customs or in the form of entering into treaty, that should be treated as source of international law. This is what is the positivist approach. They said that the empirical method should be followed as to what state actually do rather than what state ought to do. Right? This is not the logical correct observation pertaining to international law. They say that whatever state has been following, that becomes the law of states, law of nations. Right? It is not what ought to be done by a particular state. Right? So they said that there has to be some element of scientific experiment, right, which need to be followed so as to verify a particular hypothesis. Why state enters into a war? There must be some reason. There must be some, like not reason. There must be some, like situations which compels a particular state to enter into war. Let those particular situations be forming part of international law and accordingly dealt by a superior law. Right. So the idea was, and like from this particular thought is philosophical thought that the terms and concepts must not be derived from reasons altogether, right? They must be what actually happens between the state. If states agree to stay in peace, that should be the force, even if there are certain like doubts between the states, right? And even if they are not following the larger principles of law, right, which is maintaining security and observing the like the territories, respecting the territories of others, that is not the concern of a state. A state generally do not form that particular concept. But of course, what has been prevailing at that point of a time should be remain the law of, should be part of international law. So state what actually do is the key, and what ought to be done or given on the basis of natural law is not the area of believe in that particular aspect. And they said customs which have been recognized by a state became the essence of law of nations. Because this already centers around this particular question as to what is law of nations. Naturalist says that state is also something which is similar to what we say a subject of a state, subject for law. So state are also subject for law, and since the subject of law is also bound by certain natural principles, state is also bound by certain natural principles, which was not the observation of the philosophers beyond 12th, like prior to 12th century, because they said that state cannot be subject to it. People can be. People can definitely be subject of certain laws, and accordingly, the law of diplomacy developed at that point of a time. The law pertaining to private relations developed at that point of a time. But law of nations developed as and when this particular diplomacy extended to next level. Reasons came into existence. States were involving themselves now. Now they have been entering into agreements with other states that we are not going to enter into war. People definitely, like there is no such requirement of people entering into an agreement. State have been entering into agreement, and that became the genesis behind emergence of positivist approach towards international law, because they said that once the state has agreed or entered into certain agreement or has been following a particular practice, that is what needs to be taken into account, not this other people, the individual, their actions, or the organs of a state, what they've been following, how they've been making a particular law. That is not the source of international law altogether. Now, there is also influence of natural law into international law. That's what I have already informed. In fact, in the earlier classes, I've already given you the name of Dutch scholar, right, Hugo Grotius, and his work, A Law of War and Peace. The basis of that particular law of war and peace is that even states are also subject to certain laws. And that's why they believe that this is law of nations, right? There is the understanding of law of nations under positivist approaches, what they are following, what they are doing. There he says that it is not about what a state has been following or doing. It is what a state ought to be following or doing. So there should not be war. There should always be a case of peace. There should always be protection of territories of others. There should always be following of humanitarian law. That as and when you have captured the soldiers of enemy state, you will be treating them properly. Right? All those aspects. So they said that the root of this particular philosophy is not what state actually do. It is what they ought to be doing. And that's what is the focus of natural law schools, right? So greatly you will see that international law by the time 21st century got greatly influenced by 20, like by positivist approach. But the two world wars, right? They like completely shape the very basis on which law was perceived by state altogether. Now they said that the kind of damage the world witnessed because of those wars, there is a requirement of going beyond what law is. And they said that there is a requirement of ought to proposition, right? And following the emergence of United Nations, you will see that it is all ought to be proposition that gained these important place under international law. You had like natural rights emerging, and from those natural rights, you have fundamental rights emerging, right? There is a great debate, like because uh, between two scholars. I'm not recollecting the name of those particular two scholars at this point of a time. Thomas Paine, yeah, one is Thomas Paine, and there was another scholar. Both of them being, like they were friends and a great scholar of their time, and both have different observation. Because at that point of a time in Britain, what was happening that there was a kind of agreement that entered between people and the crown, right? The crown says that I can only support you till the moment you support my existence, right? Because there was not normally many conflicts that were taking place between various organs in Britain, right? Judiciary was having its like role. Parliament was getting superior. Crown was getting lesser like recognition. But there were wars also going on, and those wars have been fought on the name of crown. Now, crown says that if you can give your rights to me, I will protect those particular rights, right? And that ultimately became the basis on which, like the queen became the head, right? And this was rejected by Thomas Paine, and he says that of all the rights that human being, like it's natural that like if there is a head of a state, you can give all of your rights to that particular state, but there are certain fundamental rights, right? Human right was first coined by Thomas Paine himself. It's because in Google you will find out it's Churchill. It's not the Churchill, it's Thomas Paine who first developed this argument of human rights. And the genesis of bringing that argument of human rights is again natural law. So natural law, which found no place between 17th century to 19th century, re-emerged at that phase. And it says that there are certain natural rights available for every individual. Even like, and they continues for generation to come, because the agreement that was entered with the Queen was that all the citizens of Britain, even the future generation, they will provide, like they will serve the Queen, right? There will be no demand of rights as such. And in lieu of that particular agreement, you will be provided protection from the enemy states. Now, Thomas Paine was critical of this particular observation. And he says that as a matter of birth, there are certain natural rights which every human being obtains. And irrespective of any agreement that has taken place, those rights cannot be provided. They remain as a right by the mere birth of that particular person. And he talked about natural rights. And the entire argument of natural right gained its greatest momentum under the aegis of United Nations when they declared UDHR. Right? UDHR, the Universal Declaration of Human Rights. And from that particular source, the entire jurisprudence pertaining to human rights emerges. Right? Though it has its roots to natural law, from natural law to natural rights. And from there, when it has been placed into the text of the Constitution, it became fundamental rights. Right? If you look into those particular fundamental rights, the roots of right to life, right to equality, the right to freedom of expression, or liberty for that matter, have to the natural law, right? But they changed themselves, right? So natural law came natural rights, because natural law cannot survive the kind of questions jurists were raising to them. So they said that there are certain natural rights by mere birth of a human being. And that natural right ultimately, when it places itself into the text of Constitution, becomes your fundamental rights. In fact, when we say that fundamental rights are synonymous to natural rights, right? So naturalism also gained it importance. They said that there are certain inherent needs of human nature, right? And experiences has suggested that those particular inherent needs leads towards peaceful maintenance of the community. This is what they've been arguing on behalf of international law, right? So one of the important requirement is that these people do know, and in fact state, because of its continuous engagement into wars, demands peaceful existence within a community. And they always cite this particular Treaty of Westphalia as an example, because that particular treaty was possible. The agreements among the states was possible only because of the experience that they have developed and the need that there shall remain peace and harmony within the community. And for that matter, they agreed that state will recognize the boundaries of other states. They will recognize the territories of other states, right? So that basically is the source of Westphalia, right? So they say that in order to have peace, universal human community must maintain a willingly point wherein common human interest must be taken care of. And this particular source is found from natural law itself, right? When it says that law has to be just, fair, and reasonable, right? How it can be just, fair, and reasonable? Because there is a requirement of ought proposition with law. Law is not what it is. There is something ought proposition of law. So if you prepare a law and if it does not fits to that particular conscience of the society, it cannot be treated as law, right? If you have studied the debate, Hart and Fuller debate, this can be properly found in the work of Lon Fuller, right? When he was answering to that particular work of Hart, HLA Hart, because Hart believes, and there was, what happened in that particular case. I will just give you facts. The rest of that particular aspect you have to study by yourself. There is a very interesting debate that took place between these two scholars, HLA Hart and Lon Fuller. Both came up with the book Concept of Law. Hart came, Fuller came up with the book Law of Morality. Right. The reason for those two particular books is the debate that took place between these two persons. The debate between Thomas Hobbes and the other scholar, most probably I will be recollecting it later on. I will inform about that particular debate as well, which ultimately resulted in the making of human rights. Right. And it's a very interesting debate. Both of those two particular scholars are important and essential for understanding. That's why if you're understanding a subject, understand it from the perspective of jurisprudence. Then it becomes very easy to understand why that particular subject exists. What is the reason for bringing of that particular subject, right? So this is what is being understood by naturalist. And they said that since law have a common goal, right? So, no, I was referring to that particular fact as to why there was this debate that took place between positivist and naturalist. Now, in fact, if you read further into various sources, you'll find out that as such, Lon and Fuller was not a naturalist, right? But he made an argument and countered Hart's argument. And he was, like, given this titleship of as a naturalist. But if you look into his work, they do not centers around natural law schools philosophers. But overall, after the work, that debate that took place in writing in various places, in books, in fact, a review of the books, both of these two scholars made review of each other's book as well. Right? It continued for roughly around 15, 16 years. Both of them were arguing their case. And it happened because of the trials that were taking place in Germany under like the Hitler's regime, the Führer's regime, right? And because of the judgment that were delivered from those particular courts, Hart was of different opinion as to why those particular judgment holds their relevance. Fuller was of a different opinion. Like, because Hart was of the opinion that the judgments were coming from a court, from by a law, for the people who are under the habitual obedience of those particular laws or the regime. So we cannot say that these laws are not law at all. They are law for that particular regime. It continued for a significant period of a time, though the outcome of those particular law was not correct. Right? He says that you can have a different outcome of law because you cannot prosecute a person. Like, that's a very interesting scenario. But Fuller was of a different opinion. He says that the mere existence of a law in a particular society will have no guarantee that that particular law is a law for that society. What is required that along with law, you need to have elements of morality as well, the reasons as well. Because the moment you bring the elements of morality and reasons, it will have it will serve the common good, it will have common conscience, and that will ultimately result into its common acceptance, greater acceptance. Right? Hart was of a different opinion. So concept of law and law of morality, they appeared, these two greatest of the book in jurisprudence, because Hart has been credited to a great extent, are the product of this particular debate. This is the debate in international law as well, right? Because positivists say that what state are doing is the law, because customs is the law. Like the because
Mahalaga
the
था.
logic behind positivists
नहीं
is that they
लौटेंगे.
want scientific evidences for law, and they said that we can like, where do you find a like natural law? It is available everywhere. Can you provide any particular source? The natural law school scholars do not have any answer to this, because they say that our source is reason. And when they were further arguing, they said that like, it became very ambiguous. Like, morality becomes ambiguous, defining reasons become ambiguous, and then the ultimate aim of naturalists that there has to be a law of the highest order, right? So positivists say that this is something which has no like scientific basis. Anything and everything can fall within the meaning of that particular morality and reason. Positivist says that we can find the source of law. Look what state have been following. They have been entering into certain customary practices. This is what other states are also been following. So there is a genuine recognition of all the states to follow a particular practice, and it ultimately attains the status of a custom. This is what law is. Or states have been entering into certain agreements because each state is sovereign, right? And they've been entering into certain agreements, and when they are entering into agreements, there is certain kind of pact that has been entered between those two states. Pacta sunt servanda, we'll refer that particular point as well later on. So there is a pact, which meaning thereby states are willing to fulfill those obligations which they have informed or have casted upon each other. So this is another source of international law for us, bringing in. So these sources have not been coming because what state ought to be doing. These sources have been coming because this is what it is. This is what state have been following. So this is what law ought to be, and that ultimately became the greater part of international law. You had international organizations emerging. You had like more treaties like entered between states. So positivist became the focus. Positivism became the focus. But two world wars, they shook the conscience of world altogether. And they said that no, we cannot rely on this particular aspect of what law is. There has to be an ought proposition as well. State can enter into any kind of agreements, provided they are entering into those agreements with the larger goal that they are not affecting the interest of others. They can make any particular law, provided there are respect for basic laws as well, basic universal laws, right, which affects the rights of everyone. And they have been granted to everyone because of their birth to this world altogether. So state cannot enter into any agreement with other state wherein they will not accept this particular aspect. And this particular phenomena was not just because of two wars, because if you'll dig deep, you will find out that there was this issue of like slavery as well. There were these issues of racism as well, right? So these particular incidences were also like critical towards development of law from a different perspective, international law from a different perspective, which is naturalist. So you will have what we have in present time is an amalgamation of every such requirement, right? You will have positivist approach wherein states have still, like because the greatest source of law or greatest source of international law in present time is the agreements. Now there are new sources also emerging, which is judicial pronouncement. Those are referred under Article 38 itself, right? The first is customary, like the conventions, laws, and treaties, then customary principles. Then you will have, like these judicial pronouncement. In fact, there is another source of law which is emerging, which is the writings of the greatest scholars who have been recognized by world altogether, right? Their writings also become source of international, but to a very smallest amount of extent. The greatest source still remains the treaties and customs. Judicial pronouncements are also limited to great extent, right? But they have been emerging, right? So now, yeah. So you have this particular resolution as well, right? That whatever state, because natural phenomena is also being seen, especially in law of sea, because like when we'll be discussing about law of sea, and that's my area of interest more, like so. I have taken that particular example over here, but the better example would have been the acceptance of UDHR, right? Principles by the states, and then the regional acceptance. European Union emerged that also, and it came up with its own provisions related to protection of human rights. African Union emerged, all those aspects, right? So, but this is important. This particular resolution number 2749, right? This says that the seabed and the ocean floor is declared as international seabed and of common heritage. So anything which is outside the territorial domain of a particular state and is in the high seas, right? Which is like which is for every state, and any resource which is lying on those particular high seas beneath the those high seas, those are common properties. The world together can utilize those particular common properties, right? Those will not be remained in the hands of one or few particular states altogether. Law of sea is the greatest development in this particular regard. The efforts towards bringing togetherness, right? And it has its own checkered history. It's not easy that the world altogether came to a particular agreement, right? Very easily. It was very difficult for convincing the states to come together, sit together, and declare this particular point that the resources in those high seas are common heritage, can be utilized by every state and for the interest of every particular state, right? To that extent, the idea is natural law. Wherever you will have universal declarations, the idea is natural law. Wherever there will be the reference of the term common heritage, the idea is natural law. Wherever there will be reference of protection of interest of individuals, say for example in terms of like the refugee laws or asylum, therein also the reference and influences of natural law, right? But wherever you will talk about like recognition of customary practices, or say for example what can be treated as treaty, right, there will be a reference of positivist influence, right? Because state what they've been following becomes customs, right, irrespective of a fact whether that particular custom is correct or not. Now there are many other requirements, but previously when this entire arguments of like lawmaking pertaining to international law was developed, it was centered around customary practices. In fact, the work that I've quoted recently of Hugo Grotius, way back in like 1625, the law of war and peace, Those were all recognition of customs at that point of a time, right? Because Treaty of Westphalia happened there afterwards. So even that book, which has been considered as a landmark book or a treatise that collected all available customary practices in one place, like that is based on customs, right? So Hugo Grotius' book, because he has been considered as father of international law, there are certain doubts. Stark believe that there are doubts because if you will consider him father of international law, the only source that he has referred in his book is of custom, right? There is a small understanding pertaining to treaties, but that has not been significantly forming part of his particular treatise altogether. It is greatly influenced by custom, and international law in present time is beyond custom. It is beyond treaties for that matter. Right? There are other sources which are also gaining importance. Sources like the General Assembly resolutions, sources like the resolutions of Security Councils. They do not find their place under Article 38 altogether, but they also have relevance and importance. Declarations, they're also becoming relevant and important. UDHR is a classical example to this extent. Conventions, for that matter, they are also becoming important sources of international law. So there are new sources of international law which are emerging, but we still regard Hugo Grotius as the father of international law because for the first time, and in fact, many scholars will go again to a great extent and saying that he has referred to the work of earlier scholar. I'm not recollecting the name, Gentilis, I think, and he did not acknowledge him properly, which generally happens with Austin as well, because many believe that Austin has done nothing more than what has been already like informed by Bentham, right, whom he was greatly influenced with. So it generally happens, right? Because that's a human nature. You will dig deep and you will find out more, this evidences, and that happens normally within these scholars. But by and large, that book is a landmark book, Law of War and Peace, right? De jure belli et, pacis. That's the name altogether, but very important, very relevant book on at that point of a time. Now, this is something which we have already covered, that earlier natural law schools believed differently. They were not concerned about the newer natural law school, which is based on rights altogether, which is based on common like aspirations. The earlier natural law school, say for example, Samuel Popdorf, I have quoted over here, centered around his argument on morals, right? And they denied validity of any particular role of custom altogether because they said that there is no such customs. Naturalists never believed in custom, which is obvious because the positivists never believe in morality, elements of morality and reasons into lawmaking. So naturally, if you are a naturalist, you will target the source on which that particular school rests its argument around, right? The sovereign. The naturalist doesn't believe in sovereign. They say that even the sovereign is subject to certain laws, and there is no such sovereign altogether. Sovereign has been assigned with certain work, which is what is our concept of dharma, right? In our dharma concept as well, we argue on the same lines that there are certain principles, certain rules which are beyond the king itself. Even the king has to follow those particular rules, and that's what is called dharma, right? But nevertheless, that's what by and large is the jurisprudential argument pertaining to the concept of international law. Just a second. We have now, okay. From next class onwards, we'll start with codification of international law, right? Now, this is the important aspect of international law. How does codification of international law developed? And then we'll move into the relationship between municipal and international law and certain other and subjects, right? We'll cover subjects, relationship between so what now by now we have understood how international law was perceived by various schools, how it was perceived by states, but then we'll look into the next part of international law. And this is the most important phase of international law, that codification started. That whatever is custom is not something that the state were willing to accept because there are certain customs which were not followed by a particular state. Now they said that instead of bringing customs or customary practices argument, let's codify it, put it into black and white. Now, and once it has been put into black and white with the acceptance and signature of all the state, it becomes binding upon those particular states. So that is a very important role that has been played, and it has its roots again to the history. There was a thought, an argument which was raised by various scholars. On those lines, this codification of international law takes place. And it is because of this efforts of codification of international law that you have United Nations or as an organization in existence. Right. There are various efforts which are still ongoing. Right. There is an International Law Commission which is mandated by United Nations Charter itself. Right. We'll refer to the provisions of Charter which assigns International Law Commission to come up with the process of codification. Now, there is not just International Law Commission, there are other organs of international law which are also playing significant role towards codification of international law. Right? So we'll cover that particular part in the coming classes. Any doubt if you'll be having, read the introductory part of books that I have shared with you. Any doubt if you'll have, come with those particular doubts in the class, because the jurisprudential aspect of every law is the most important aspect. Rest thereafter will be easy to understand. Right? Okay. So anyone who was left with the attendance jointly